Imagine this. You're a Filipino citizen married to a foreign national. Your spouse gets a divorce abroad, perfectly legal where they are. But should you stay legally married here, bound to someone who's already moved on, just because our laws are different? It's a tough question, right? Well, today we're unraveling a landmark Supreme Court case that tackled this exact dilemma head-on. It offers a really crucial path forward for Filipinos caught in this kind of international family law tangle, looking for their own new beginnings. Welcome to the deep dive. Today we're getting into a really significant case. Regie David Tsutsumi, petitioner, versus Republic of the Philippines respondent. This decision came down on April 17th, 2023.
That's right, GR No. 258130. And it's significant because it really addresses how Philippine law grapples with the reality of global marriages and, well, divorces.
Exactly. Our mission today is to cut through all the legal jargon. We want you, our listener, to really understand the core issues, what the lower courts decided, which had some twists, and ultimately the Supreme Court's final definitive ruling.
So you walk away understanding this precedent, which is highly relevant for many people.
Absolutely. Let's dig in.
What I find fascinating is how the court is dealing with such a common modern problem. This isn't just about Regie Tsutsumi. It's about the law adapting, trying to prevent Filipinos from being stuck in this kind of legal limbo.
That's a great way to put it. So, let's set the stage. What are the basic facts here? We have Regie David Tsutsumi, who's Filipino, and Hira Tsutsumi, a Japanese national. They got married way back in August 1995 in Tarlac City.
Right, and they had 2 children. Built a life for, almost 21 years?
Yeah, nearly 21 years. But things didn't work out. They cited unresolved and irreconcilable reasons. So mutually, they decided to file for divorce in Japan. That was April 11, 2016.
And that mutually decided part is key. This wasn't some messy court fight in Japan. It was an agreement between them, processed administratively.
Like filling out forms rather than arguing before a judge.
Pretty much. And that difference, administrative versus a court judgment, became a huge sticking point later on back here in the Philippines.
Okay, so they get the divorce processed in Japan. Then what? How does Regie try to make this recognized here?
Well, on March 7, 2018, they got their official divorce certificate from the Embassy of Japan. And importantly, this wasn't just any piece of paper.
Right. It was authenticated, wasn't it, by the Philippine Department of Foreign Affairs, the DFA.
Exactly. Authenticated by the DFA and even recorded in the civil registry of the city of Manila.
So, on paper, it looked official.
For Regie, it probably seemed like all the boxes were ticked. So she then filed a petition for recognition of foreign divorce with the Regional Trial Court, the RTC, in Tarlac City.
She's basically asking the Philippine court, hey, this divorce happened legally in Japan. Please recognize it here so my status matches my ex-husband's.
Precisely. That's what Article 26, Paragraph 2 of the Family Code is supposed to help with achieving that parity.
Okay, petition filed. What was the first stop on this judicial journey? The RTC in Tarlac City, Branch 64, they gave their decision June 27, 2019.
And initially, it was good news for Regie. The RTC granted her petition.
They did, so they recognized the divorce.
Yes. Recognized the divorce, declared her legally able to remarry, and ordered the divorce annotated on her marriage certificate. Done deal, it seemed.
What was their reasoning? How did they justify it?
It was pretty straightforward, actually. The RTC looked at the authenticated documents, the report of divorce, the family register, the divorce certificate, and said these were sufficient proof.
And the government didn't object at that stage?
Apparently not, or at least not effectively. The RTC noted no objection from the Republic during those initial proceedings. They relied on the rules of court, specifically Rule 132, Sections 24 and 25, which deal with proving foreign official records.
Seems logical. Authenticated documents, no objection, rules followed. A win for Regie.
A moment of relief, for sure. But it wasn't the end of the story.
Of course not. The Republic, represented by the Office of the Solicitor General, or OSG, wasn't happy.
They filed a motion for reconsideration. The RTC denied it. So inevitably.
Onwards to the Court of Appeals.
Exactly. And this is where things took a sharp turn. The CA, the Court of Appeals, issued its decision on January 7, 2021, and then a resolution denying reconsideration on November 8, 2021.
And what did they say?
They completely reversed the RTC. Threw out the initial decision.
Wow, a total reversal. Why?
Yeah.
What were the CA's arguments? This must have been devastating for Regie.
It really dismantled her case. First, the CA zeroed in on the type of divorce document. Remember we said it was a mutual agreement, an administrative divorce?
Yeah.
Well, the CA said that wasn't good enough. They were looking for a Japanese court-issued divorce decree or judgment, something formal, adversarial. They felt the certificate, even authenticated, didn't properly prove the divorce as a legal fact under Philippine rules.
So the administrative nature was the problem for them. What else?
Second, the authentication itself. Even though the DFA authenticated the documents, the CA said that was improper.
How so? The DFA is the Department of Foreign Affairs.
Their logic was based on a strict reading of Section 24, Rule 132. They argued the authentication had to come from a Philippine diplomatic or consular officer stationed in Japan, where the divorce record originated. Authenticating it via the Japanese embassy in Manila, and the DFA wasn't the right chain, in their view.
That seems like a very fine procedural point.
It was. And third, they took issue with the Manila registration. They saw the filing of the divorce certificate with the civil registrar in Manila as an attempt to, quote, circumvent Rule 132.
Circumvent. How?
Because the Manila civil registrar wasn't the original custodian of the Japanese record. The OSG later called it mischievous ingenuity. The CA felt it was a way to bypass the proper proof requirements for foreign documents.
Okay, so document type, authentication location, and local registration. Anything else?
Yes, a big one. The proof of Japanese law. You don't just need to prove the divorce happened. You need to prove the foreign law that allowed it.
Right, because our courts don't automatically know or apply foreign laws.
Exactly. Regie did present an English translation of relevant Japanese laws, but she did it a bit late, and the CA found it lacking. They said it was, quote, not fully instructive of, if not irrelevant to, the nature and effects of this specific type of divorce, the divorce by agreement.
So they felt the law presented didn't adequately explain the legal basis for this particular kind of administrative divorce in Japan.
That seems to be the gist. They wanted more specific proof linking the law to the divorce by mutual consent.
So the CA basically shut down every angle. It sounds like they were saying, maybe you got divorced, but you definitely didn't prove it correctly according to our rules.
That's a fair summary. It put Regie right back where she started, legally married in the Philippines, which understandably led her to appeal to the highest court.
The Supreme Court, what was her argument going up there?
She maintained she had sufficiently proven the fact of the divorce. And she argued, look, even if the proof of Japanese law wasn't perfect, the answer should be to send the case back down, remanded to fix the issue, not to just completely reverse and leave her stuck.
And that's when she made that powerful statement.
Yes, describing herself as shackled and chained to a barren wasteland while her ex-husband was free. It really highlighted the human cost of these legal technicalities.
A very strong plea. And the OSG, what was their position before the Supreme Court?
They defended the CA's decision, echoing the concerns about the documents, the authentication, that mischievous ingenuity argument about the Manila registration, essentially upholding the strict procedural requirements.
So the stage was set. The Supreme Court had the RTC's decision, the CA's reversal, Regie's plea, and the OSG's defense. What did the SC do?
They delivered a clear verdict. Supreme Court reversed the Court of Appeals.
Reversed the CA?
Yes, and reinstated the original decision of the regional trial court.
Wow. So Regie ultimately won. That's huge.
Absolutely. A major victory for her and a very important ruling for Philippine jurisprudence on this issue.
What was the core reasoning? What principle guided the Supreme Court to overturn the CA?
The guiding star for the SC was dispensing substantial justice. They explicitly said that lower courts dealing with these Article 26, Paragraph 2 petitions need to focus on that, on fairness, rather than getting lost in rigid technicalities.
Substantial justice over procedural perfection.
Precisely. They cited an earlier case, Maranya v. Republic, which emphasizes that procedural rules are tools to achieve justice, not obstacles to it, especially when people's fundamental lives are at stake.
Makes sense. Did they mention the Manalo case? Republic v. Manalo is often seen as the landmark ruling on recognizing foreign divorces initiated by the Filipino spouse, although this case involves the foreign spouse initiating or agreeing. How did Tsutsumi connect?
Oh, absolutely. Manalo was central. The SC heavily relied on Manalo to stress the need to avoid discriminating against the Filipino spouse. They talk about the realities of the present time, acknowledging mixed marriages and, frankly, marriages that have failed.
Didn't they have some strong words about that?
They did. They said it's hypocritical to safeguard the quantity of existing marriages and, at the same time, brush aside the truth that some of them are rotten quality. Strong stuff. They reiterated that marriage is mutual, and it's unjust for one party to be free while the other remains bound. Tsutsumi builds on Manalo by showing how to prove these divorces, especially administrative ones.
That's quite a statement from the court. Okay, so grounded in substantial justice and building on Manalo, How did they address the CA's specific points, like the sufficiency of the divorce documents?
They disagree strongly with the CA. The SC found the divorce certificate and the certificate of acceptance, authenticated by the Japanese embassy in Manila, were actually the best evidence available for the divorce.
Even though it wasn't a court decree.
Yes. And crucially, the SC pointed out something the RTC also noted. The state, the OSG, never actually questioned that the divorce happened. They only questioned the way it was being proven.
Ah, so the fact of the divorce wasn't really in dispute.
Exactly. The SC, again citing Manilo, said if the other side doesn't object to the documents themselves, they should be admitted as official acts. And they confirmed Japanese law does allow divorce by mutual agreement, so demanding a court decree wasn't necessary or appropriate here.
Okay, that tackles the documents. What about the proof of Japanese law? The CA found that lacking.
The SC acknowledged, yes, foreign law must be proven as fact. Courts can't just guess what Japanese law says. That's standard. But they disagreed with the CA's assessment of the proof Regie provided.
What proof did she provide again?
She submitted an English translation of the Japan Civil Code, specifically Articles 763, 766, 767, 768, 769. These articles explicitly cover divorce by agreement, custody, changes in surname, property division, basically all of the relevant aspects of the divorce she obtained.
So the content was there, covering the specific type of divorce.
Yes, and the SE found this sufficient.
But what about the authentication of that translation? The CA was strict about needing certification from the consulate in Japan.
Right, and the SC looked at the process Regie actually went through for that translation. It was quite extensive.
How so?
It was signed by Regie, notarized in Tokyo, then certified by the director of the Tokyo Legal Affairs Bureau, then certified again by the Japanese Ministry of Foreign Affairs, and finally certified by the vice consul of the Philippine embassy in Tokyo.
Wow, that's a lot of layers of official verification.
Exactly. The SE saw this multi-step authentication, involving both Japanese authorities and the Philippine embassy there, as more than sufficient. It satisfied the need to prove the foreign law as a fact. It directly addressed the CA's concerns, just through a different but equally valid chain of certifications.
So the SC provided a clear pathway. Thorough, multi-layered authentication works. That's practical guidance. So wrapping it all up, what was the SC's final order?
The final declaration was clear. The Supreme Court recognized the divorce Regie obtained in Japan. It declared her legally free to remarry under Philippine law, and it ordered the annotation of that divorce onto her Philippine marriage certificate.
Justice served, finally.
Substantial justice, yes, aligning her legal reality with her actual reality.
Okay, this is a really important decision. Let's distill this for our listeners. What are the key doctrines, the main takeaways from Tsutsumi v. Republic?
I think there are three main ones. First, and maybe most importantly, is the emphasis on liberality in recognition of foreign divorces under Article 26, Paragraph 2.
Meaning courts should lean towards recognizing these divorces.
Yes, especially when it's the foreign spouse who obtained it, to avoid that unfair situation where the Filipino is still married and the foreigner isn't. The goal is substantial justice, freeing Filipinos from these broken bonds.
Okay, liberality and substantial justice. What's the second takeaway?
It's about proof of foreign divorce documents. The SC clarified things here. An authenticated divorce certificate and certificate of acceptance, even if it's from an administrative process, not a court, can be enough evidence.
Especially if the state doesn't actually contest the divorce itself, right?
Exactly. If the existence of the document isn't challenged, it simplifies proving the fact of the divorce.
Good. And the third key takeaway?
Proof of foreign law. This is often a tricky area. The court confirmed that an English translation of the relevant foreign law is needed. But crucially, if it's properly authenticated through a multi-step process involving foreign officials and the Philippine consulate abroad, that's sufficient.
So that detailed chain of certifications Regie used, that sets a viable standard.
It provides a clear roadmap, yes.
Right.
It shows how petitioners can effectively prove the foreign law as a fact.
So this deep dive into Tsutsumi v. Republic, it really goes beyond just legal procedure, doesn't it? It feels like it underscores this idea that justice sometimes means looking past the strict letter of the rule to the actual human impact.
Definitely. For Filipinos in similar situations, it's a significant beacon of hope, a path to closure, maybe a new chapter.
But it also makes you wonder, doesn't it? What does this evolving view of law mean for how we think about family in a world that's so much more connected, where laws and lives constantly cross borders?
That's the bigger question, isn't it? How law adapts to these global realities, balancing tradition with the need for fairness in individual lives.
Well, we'd definitely love to hear what you, our listeners, think about this landmark decision. What part stood out most to you?
Yeah, let us know. Share your comments. Maybe favorite this deep dive if you found it useful.
And tell us what other complex topics you'd like us to unpack in the future. If you found this deep dive valuable, please don't miss out on future ones. Hit that subscribe button, follow us wherever you get your podcasts, and share the deep dive with anyone else you know who likes to stay informed quickly and thoroughly.
We'll be back soon with another stack of sources, ready for the next exploration.